All right, well, welcome back to Module 4 for NR 567. We talk about NEPA in the courts. Tony Chang provided a nice intro to the judicial review aspect of NEPA along with case law development. So we'll jump right in and discuss the general structure of the legal system. So there's 4 sources of law that are relevant to natural resource policy in the U.S. So the Constitution, which is a living document, so very difficult to change, what we call very durable. We have statutory law, so written by legislature at the state or the national level. And NEPA is an example of a statutory law. So it designates key actions, programs, and services. Then we have administrative rules and regulations. So the rules and regulations of the executive branch, where this fills in the details left out by statutory laws and is developed through the agencies. And then what we will talk a lot about in this course and in this module is what is called case law or common law. So court rulings, and these set the precedents for future actions and for future court rulings. So to make sure there are any procedural or substantive violations of any constitutional, administrative, or statutory law. And so our system is divided into 3 different levels. So the district courts, the 13 Court of Appeals that are organized into 12 regional courts, which are all subject to Supreme Court rulings. So in this next slide, you can see the organizational boundaries of the courts. There are 12 courts, and they're shown here geographically, and how they're geographically apportioned. You don't see a 12th because the 12th is actually subject-oriented and nationwide. And so the next slide shows this organizational structure, and it shows the 2 routes to get to the U.S. Supreme Court. So one is through the U.S. District Courts and Court of Appeals that we just saw, as well as the state district courts and the state Supreme Courts. So looking at this a little more closely, and so how do these district courts operate? So the judge will determine and examine the factual evidence to determine the substance of what is in question, and to determine whether or not a violation of the law has indeed occurred. And so they'll determine standing, so whether or not the plaintiff has a right to sue, and ripeness, which can be thought of as, when is controversy ready for, when is it's time for judicial review. So it also determines what laws apply to the case, and it can impose appropriate remedies. So it can clarify which statutes have priority over one another. It can force an agency to alter the way it's analyzing its alternative. So in this case, like some of the examples we've talked about is beefing up an EIS, so doing some kind of more intense analysis that's enforced by the court, or impose some sort of injunction, which we'll discuss further. So looking at these district court powers and kind of just defining them for this class, restraining order. So this restricts the action before, during, or after the case proceedings. An example is a temporary injunction. So this stops action during the case proceedings to avoid further harm while a decision is being made, or a permanent injunction stops action after the case has been ruled until that harm that's been identified has been reversed. So the next level of the court system, the regional appeals court, is appeals must be made by the losing party. Grants or denies certiorari where a court reviews a previous ruling from a lower level of court. So they can address questions of law and constitutionality, assume the facts of the case have been settled in the lower court, and examine whether the district court correctly applied the law, often as a summary judgment. So they can affirm or deny and possibly remand. So when they remand the decision, they send it back to the lower court to review. So at the highest level of our courts is the Supreme Court. And so at this highest level, again, appeals are made by the losing party. They're extremely limited in the cases that they can hear, so they deny a considerable amount of cases. Similar to the previous course, they address the questions of law and constitutionality and whether or not the courts correctly applied the law. They will confirm that ruling or deny it or send it back. So the next slide is an old slide, needs to be a bit updated, but the new picture has this same exciting crimson backdrop, and here you see most of the current Supreme Court justices. Brett Kavanaugh has replaced Anthony Kennedy, and Neil Gorsuch succeeded Antonin Scalia from this last picture. So the next slide shows the number of cases specific to the U.S. Forest Service. And you can see that NEPA is litigated far more than any of the other acts that it's compared with here. This breaks down a little bit into Forest Service wins, losses, settlements. And so you can see that NEPA is highly litigated, and I've heard people, who are doing NEPA sometimes feel a lot of pressure that the analysis they need to do needs to be litigation proof. So they have this fear a lot of times that's associated with them doing any type of analysis. So NEPA is fairly self-regulated, by the agencies. The agencies are left on their own to determine the impacts of their proposed action. This requires public oversight and court enforcement to keep the agencies in line. So there are several standards of review that are used. We've talked about this: arbitrary and capricious. So how does your information, back up the decision that you made? When an agency, there can be an abuse of discretion when an agency arrives at a decision through its own agenda without using the boundaries of laws and regulations. We've also talked about this idea of deference, that the court trusts the opinion of the experts, and they're reviewing the NEPA documents for procedural items, and it doesn't make sense that the reviewers on a court level don't have the same training that the experts do, so they defer their that expertise to them. So we come back to this hard look. So this review is accomplished by taking a hard look. So did the agency thoroughly identify and analyze the impacts of the proposed action and the alternatives? They need to examine relevant data and articulate a rational explanation for its decision. The rational connection between the facts it found and the choices it made. And the courts will take a hard look at whether the decision was based on those relevant factors, or whether there's been an error in judgment or an irrational decision. So the courts will also use the rule of reason. So a careful review of all steps of the EIS to make sure the agency has made a reasonable decision based on the information. The majority of cases involving NEPA address that the agency did not use the best science available. They left some information out, or the interpretation, the analysis of that information was insufficient, or the agency ignored conflicting information or evidence within the analysis. So again, we see more lawsuits under NEPA than any other environmental statute. Environmental impacts must be given a hard look by the agencies. Court will review their own hard look at the agency's work. Agencies had to show their work, the clearinghouse argument for NEPA. So in NEPA litigation, just worth pointing out, is or can be seen as a stalling technique, and so litigation is put into place in order to maybe stall the process, or to make the process more costly or too costly for whatever agency is trying to perform the analysis. And then courts defer to agencies in determining how to actually do an EIS. And the NEPA at its best is the public brings in new science and helps the agency manage vast amounts of information. So this is when maybe there's some gaps in the analysis. The public makes the agency aware of this analysis. It's incorporated into the document, and then the document becomes more efficient and provides better information for decisions. And so finally, we take a look at this last slide with some key court decisions and case law surrounding NEPA. We had the Calvert Cliffs. So the plaintiff's primary argument was that the rules did not comply with NEPA because the agency did not require information on impacts of the nuclear power plant. The court sided with the plaintiff and said that the government activities needed to be rigorously assessed before the proposed activity occurred. So a pretty important step in case law there. You had Jersey Jack, which was the Forest Service was a planned timber harvest in a roadless area. So they prepared an EA for a gravel road to access the timber. They issued a FONSI, and that just was for the access road and not for the timber sale. So what was found was the agency had discretion to decide the scope of an EIS or an EA, but must consider cumulative actions and the effects of those actions. So the last case that we have here outlined is this Robertson versus Mathau Valley City Council, where it was a ski resort EIS and looked at the effects of different levels of analysis for a special use permit. The findings were that the agency did not have to mitigate adverse impacts as part of the EIS. So some landmark cases as far as the case law goes, and there's plenty of others to review, which a lot of examples you'll see from your readings and from our continued work. So thanks